A very good evening to all the participants and a special good evening to today's resource person, Dr. Deevanshu Shrivastava. I thank Mr. Deevanshu for, in fact, taking out his invaluable time and agreeing to deliver a lecture on a very important topic, especially relating to the digital world. And a brief introduction. Of course, it's already circulated to all of you, but I think it will be my honor to introduce Dr. Deevanshu Srivastava, one of the very young academicians who are doing tremendous work in the field of, in fact, legal pedagogy. And he has about 10 years of teaching experience, having obtained his LL.M from National Law School of India University, Bhopal, and he also cleared his UGC NET not once but twice, and also the Madhya Pradesh State Eligibility Test, which is equivalent to NET. And good thing is that he has completed his Ph.D. in intellectual property laws from Barkatullah University, Bhopal, and he also enriched himself with very useful diplomas which are related to his field, like diplomas in cyber law, medical laws, and media laws. And at a very young age, he has contributed a lot as far as the publications are concerned. He has 29 paper publications, 25 paper presentations, and attended number of workshops, conferences of international repute. And he's also on the editorial boards and advisory boards of various legal platforms, and very in fact avid participant in the co-curricular activities like the debates, the Moot Court activities, legal aid camps, and similar activities. And he is also a much decorated teacher, young teacher, having been awarded Excellence in Research Award not once but three times, 2015, 16, 16, 17, and 17, 18. Then again, outstanding performer for the award for the year 2015-16. Then again, Excellence in Research Award 2018, Best Faculty Award 2019 by Arjun Das Gulati Foundation in collaboration with Allahabad University, Allahabad. And he also received the Best Faculty in Law Award at the International Academic Awards in Dubai and in October 2019. And he has a special interest in IPRs, business laws, drone laws, media laws, and public policy. And as far as today's topic is concerned, I think all of us are aware of the fact that any internet domain which has to be protected needs to be registered as a trademark, in India at least. And we have number of issues like, Rediff versus Radiff, Yahoo versus Yahoo India, and many more. I think anyone who visits the domain name disputes which are released by the World Intellectual Property Organization on a daily basis, you come across a wide variety of cases which are coming up, whether it is top level domain name or GLTDs. There are many other issues, ICANN procedure and understanding with the other registration agencies. So this is a wonderful area and an evolving area. Now, before I call upon Dr. Deevanshu Srivastava, I must inform him that here is a group of IP enthusiasts who have been with us for almost 6 months, a little over 6 months, in fact. And we are very happy that this is the Silver Jubilee edition in a way, because 25 episodes, and he is delivering the 25th lecture in the Know Your IP online lecture series being organized by DPIIT IPR-Chair, Osmania University. And we are very happy to provide a platform for the interface between Dr. Deevanshu Srivastava and all our loyal, dedicated, and dynamic participants. Over to you, Dr. Deevanshu.
Yeah, thank you so much, Reddy sir. I guess it was a very humble introduction that you provided, and also a very wonderful tempo laid for today's topic. So which I guess, and I would really compliment the entire team at the DPIIT IPR-Chair Osmania University, led under Reddy sir, that you are doing a wonderful job. And as an IPR teacher, I guess the best thing we all can do together is create that environment. And your title of this series, Know Your IP, is doing that wonderful job. So I welcome everybody to this particular topic, and internet domain names and trademarks in cyberspace. This is what we'll be discussing on to. Now, what under this particular thing, we have divided it not only to one perspective, but how the domain names in the internet and what are the issues that are related to the trademark, and I'll relate it to both the trademark infringement and the trademark, uh, how it can be protected as well. And the domain today that we'll be seeing would be a cyberspace. So the contents of our today's presentation would cover number one, the domain names. What are the levels of the domain name? What is that international body that was also referred by Reddy sir, the ICANN? How are the domain names, the addresses, or are they, or can somebody be claiming a trademark over the same? What are the domain name disputes? What are the types of domain name disputes? And what are the remedies available to someone who is the victim? Moving to the first and the foremost, that what exactly is the term as we are referring on to is a domain name. Now, with the advancement of new technology, every person wants to have an access to the cyber world, especially when we talk about the merchants or somebody who is a seller or provider of a service in the market. Now, the past 2 years have also taught us that the most important thing that we see today is even when the entire world was on a close down, or was on a lockdown, we saw the trade and other things have not been stopped, and things were even proceeding through the cyber world. And we are really thankful for the same. I guess this entire series is also one of the wonderful examples of how technology can come handy to us. Now, to navigate through this vast global collection of interconnected computer networks, that is the internet, the domain name systems were invented. And in the preceding slides, we'll use this word as a most common used word. Domain names are, and the domain name system is particularly that system which is combined of the domain names together. Now, what is this domain name and what are they basically help on to? To understand in the most layman language, domain names are the reflection of the brand as we have seen them on a television commercial in our TV sets, as we have seen them on the billboards when we are traveling through the metros, through the buses, through our own transports, the billboards which are there, or when we are reading a magazine or a book in the form of the magazine ads, and even on the side of the buses, metros, trains, etc. In the similar format, these domain names are the highly visible names well shown in the cyber world. So if somebody needs to express their own brand in the cyber world, it is that billboard which helps us to locate that particular brand on the internet. A domain name is primarily used to identify one computer from the millions of the others connected to the internet, enabling the users to send an email, to access the web pages, to transfer files, and many more on that particular line. Now, as in the similar format, no two people can have the same telephone number. In the similar way, no two organizations can have the same domain name. And when I'm talking about that the same domain name cannot be used, it is generally reflected with an IP address, that is an internet protocol address, consists of multiple levels identified by both the numbers and names. The number consists of 4 parts separated by the periods, which is in form called as the dots. So for your ease, for your thing, I have given that example. This can be reflected in this particular format. So these are the 4 parts, as you can see, separated each one by a dot or a period out there. So this consists of 3 digits, dot 1 digit, dot 3 digit, dot 3 digit. So it is 173.00.133.225. This is also a separate domain name. And if we come it with a string number or in the forms of the names or an alphabet, this could be reflected as www.jlu.edu.in. For the sake of it, I have utilized and used my university's website and my university's domain name as a best example to refer it to each one of you here. Now, as to what is the basic thing inside a domain name, a domain name can categorically be divided into 2 levels. The first and the foremost, as also mentioned in the opening remark by Reddy sir, that it is a top level domain names, which is generally showcased as the TLD, is divided into 2-letter country codes, which is CCTLD, and this CC is the country code in the short sort of format. TLD stands for top level domains. According to the ISO 3166 standards, such as .in for India, .ar for Argentina, .fr for France, .au for Australia, so on and so forth. So as in for October 2009, there are 21 generic top level domain names and 252-letter country code top level domains that was there. The reason why I'm mentioning October 2009, that is a basic of an year which saw a major development and uniformity in the form of a domain names through ICANN and other process. The 3-letter generic top level domain names, which is generally referred as the GTLD, of which the important are .com, .org, .net, .edu, .gov, .mil, .int, etc. Now, for the sake of each, and I know many of my friends who have joined us today are already aware of these particular things, but taking an example out here is the www, which stands for World Wide Web, .jlu is the name of that particular brand. In this case, JLU refers to the Jagran Lake City University, the university that's my parent university. The 3-letter generic TLD here is this .edu, and the CCTLD here is the country code, which is .in. So .in refers that this particular domain is registered in country India. .edu refers which is a GTLD, which is a generic top level domain that helps us to identify that this is basically an educational institution. On a contrary, it's not there to confuse you all, but also a GTLD that is being used is a 2-letter GTLD in the format of .edu is termed as .ac, which is reflective of an academic prospect. So, for example, it can be ugc.ac.in. So, UGC is the name of the university's grant commission. .ac, that it's an academic institution, and .in, that particular domain is registered that in the country called as India. The first, as we saw, was the CCTLD. The second that we called is the second level domains, and which is reflected by SLD. Now, under the GLTD, that is the second level domains are chosen by the applicant. Below the top level domain is the domain name hierarchy are the second level domains, that is the SLD. They are the names directly to the left of .com, .net and top level domain name. So in this case, .jlu would be the second level domain to that particular point. In our case, yes, .jlu and .edu both. So as in the format, .jlu is the name, .edu is the format of how this GLD is working. So the second level is generally the name with it. The SLD is more essential for our part of the discussion because domain name disputes arises here only. Why and how, I'll tell you that. The reason of mentioning this particular line here, that major disputes in the country or in the world where we see the domain name trademark disputes, it happens with the name itself. So in our case, for example, if this is my university, which is the JLU, that is the shorter form or acronym of Jagran Lake City University, and it is a registered trademark. Okay. Now, the similar name cannot be utilized by anyone in India because this has already applied and this has already been granted as a trademark. With this similar perspective is in inter-NIC, and NICs are the network information centers. Inter stands for internet. So Internet Network Information Center maintains and administers the central database of all internet domain names. Now, as and for what all points, if it is, let's take two very distinct examples. One is something which generally we refer it as the traditional ones under the trademark law, is the market where the physical market is there and not the virtual one. In the physical market, when we see, it is a perspective of how that particular thing is applied. And that is how the particular perspective, when applied, needs a recognition. So there are two things. Number one is an applicant, and number one is the one who authorizes the application of the applicant. For example, I bought a two-wheeler and I went to the RTO office of my city. So RTO is the authorizer who authorizes a 4-digit number to my particular two-wheeler or four-wheeler, as the case may be. And I am the one who's an applicant. In the similar format, then internet or in the cyber world, the person who is the owner of that particular brand registers or applies for the registration of his domain name, and he therefore becomes an applicant, and the inter-NIC, which maintains and administers the central database of all the domain names, manages the internet domain names. The second is the NSI, which is the US Department of Commerce. First come, first serve basis, inter-NIC granted Network Solutions in, that is NSI, the exclusive authority to register domain names in the .com, .net and .org TLDs on the behalf of the Department of Commerce in the United States. We'll also move to what is exactly and how this particular things will be working. But in the year 1998 November, the Internet Corporation for Assigned Names and Numbers, I'll repeat, Internet Corporation for Assigned Names and Numbers, ICANN, was formed to assume the responsibility for the IP address allocation, protocol parameter assignment, domain name system management, and the root server system management functions, and it is located in California. The restrictions for the registration are also provided as to what cannot be registered. This is again, when it comes to the country perspective, it should not violate the country laws as well. And they should also bring how the concept of the names and emblems, which we have also as in the format of a legislation, how these things are also brought into a prohibition. The current statistics, as we can see across for the registered domain names all over the world. So this is in and how the TLDs are being registered. So for the .com TLDs, we have nearly 100,349,876 domain names registered. For the .net, for .org, .info, .biz, .us, this data is available on the website of ICANN, where you can get the total number of, and this is something which has been borrowed. The purpose of bringing this here, that you can understand that when an agencies like ICANN are working, they have such huge numbers in totality to manage and to put it in a database and to see this, because this also comes into handy when the dispute arises. Because it's not only that one has a data of .com websites of this in number, but it also has a data that what and which date it got registered, who is the proprietor, and all such details. This helps us when a dispute arises, which came first. So we all remember the first usage rule under the IPR. We all remember that who is in original author or the first author in case of copyright. Now in the case of trademark, we have been using the concept of first user, that who was the first person to use that particular thing. Bringing this to a very important, and that's where I bring that this particular is a linking thing to the topic that is assigned to me today. And this is how we'll delete or see the concept and how they differ and what is used in that particular format. So as a trademark, it is used to distinguish the goods and services of one trader, and it lets the general public to associate the mark with the identity of either the product or the services or that of the owners or the ultimate traders in that particular point. And thus it is defined as the source identifier. So what is a source identifier? It is that particular point where the general public is able to distinguish between the goods of one person or the one trader or the one proprietor to that of the others. I'll give you a small example. Now, one thing that I can tell you, that today if I have or I'm using this Bose earphones in with me, and this particular thing or the Bose thing which is written identifies that this particular design, this particular combination of earplugs or the earphones which I'm using is a registered trademark of the Bose company, and nobody can use it with the other thing. Now, when we get into the market, there might, and the purpose why I'm using this particular example. Now, we all know that we have in the electrical appliances or the hardware thing, a brand called as Bosch, which is BOSH. Now, the point which I'm trying to tell you is that it is not a deceptive similar trademark. It is not something which is there to cause confusion, but it is there so that that brand have a that was BOSCH and BOSCE when it comes to the speakers, earphones, and other things. Now, in a similar format, when we see there is an increase of the commercial activities on the internet, the domain name is also used as a business identifier. So, what I'm trying to tell here, that if we see, for example, and this has been happening with us as well, we go to the market and we are in a very hurry, and to ask the shop nearby us, we go to the shop, we need a detergent powder, and we go, can you please give me one packet of Surf? And he gives you a different brand of the washing powder, and you take it and you come back. Now, have we noticed something here? That yes, asking for Surf is one particular thing which was already a brand, which we have generally under the, or as an IP student today, I would say that we call it as a well-known trademark. I would also like to give one very wonderful example, which major of us have generally made a domain. I guess the device next which I'm going to take a name is something that can be identified in each and every household. The device that I'm was telling is the refrigerator. I really hope each one of us have a refrigerator. But what generally we call it, that, and especially during the scorching summers, we say, can you get the water bottle from the fridge? And we have generally, it's immaterial of which part of the country we are residing. We generally say, can we get the bottle from the fridge? Now, have we ever noticed that fridge was a first brand of the refrigerator? So the product is a refrigerator, but it has developed that particular thing that we have started calling it by that particular name. And this is how the popularity of that particular product is often misutilized by the competitors so that they can capitalize over the popularity of the product and get their fake products sold under the same name. Very, very common example which I generally give to the IP enthusiasts in my class is the example for a coconut oil in a blue bottle. And we'll see the number of cases that I've highlighted in the next couple of slides as well, that how that particular concept have been taken. Any other very important brand that I'm reflecting out here without anything. It's only and solely for the purpose of you people to understand the trademark and the trademark disputes, how the infringement of trademark also happens with bigger brands as well. The purpose of highlighting these cases is this itself is purely educational and nothing else. So the brand of water, mineral water that I'm taking here is Bisleri. Now we'll see also that particular, it's a reported case as well. The Bisleri, you'll find by different spelling changes, you'll find many such things. That also goes with the sports brands of whether it's Reebok, whether it's Adidas, whether it's Nike. Just a small spelling changes, but the purpose is so that the counterfeited products can be utilized. Now, the very important case which even Reddy sir highlighted in his opening remark was the case of Rediff Communication Limited versus the Cyberbooth. The court has held that a domain name is a symbol that helps to ascertain the affiliation or the association of the product or the services with its owner. Now, the point which is here is very clear that if it wouldn't have been a virtual world, if it would have been a real world, the product and the name is something that reflects the owner or the trader's main perspective. In the similar way, when the world has been changed or shifted, I'll not call it to be changed, when it is shifted to the concept of how the virtual space is talking and my product is there in the virtual format. Virtual place, I'll tell you, the only difference is the product gets an abstract format. Abstract format only for the purpose of you'll call it in the form of an advertisement or an invitation to offer. That would be a better word to take it ahead. So in the cyber world, the domain name is a symbol that much clearly provides with the format of how those particular things would be taken into consideration. The domain name disputes in the world, and for our purpose, we have been taking it. Here is a wonderful chart, which is the generic name domain disputes from the website of UDRP. And you'll see the number of cases seeing a rampant change. I'll also highlight the 2 years here, which was a later part of the pandemic hidden world. And then you can see a rapid change, nearly to that of a double figure in 2020. 2021 data was still not available on the website, but to the sources that have been taken, that this has been brought under the perspective and it has increased way too much. So these are small things that we generally take, but it has been brought to the perspective that needs to be taken in the consideration of those particular point to this particular event in the format. And this is one area, believe me, which you'll see a rapid number of changes in all the perspective. Now, what are the types of the domain name disputes that we generally see? The majors are cyber squatting, the profit grabbing, misspelling and identical domain names, which is also called as the confusing idea thing. And the last is the concurrent claims. First and foremost is the cyber squatting, profit grabbing, misspelling and identical domain names, and the concurrent claims. Now, first and foremost, what exactly is cyber squatting? Cyber squatting is made up of two words called as cyber and squatting. This squatting has nothing to do with what we do generally in the gyms and other places. But when in the more format of a criminal perspective, how this has been brought, this is, or it refers to the practice of the domain names, reflecting the names of existing companies with an intention to sell the names back to the businesses for a profit when they want to set up their websites. Cyber squatting refers to the practice of the domain names reflecting the names of existing companies with an intention to sell the names back to the businesses for a profit when they want to set up their websites. So what is this? This is basically utilizing, this is basically capitalizing over the name which has already been established. So bigger brands, when their name has been utilized and you land, many times you might have seen that in a hurry to type a domain name, you have misspelled it and you have landed to a different website. And that website is also dealing in the similar kinds of products or services. But those are the fake ones. And that's the biggest reason why these things have been brought across. I'm here do not mentioning this particular fact that there are fake websites where, and I guess during the pandemic and other things, this site has also been highlighted a major, many of these social media handles have been reporting these things. The awareness programs by cyber polices across the states, across the country, have regularly been bringing these particular things. That is all how are these taken into, but those are all more towards the cyber crimes that is not directly related to what we are studying today as our subject. Now, in the US, we have the doctrine of delusion and an anti-cyber squatting consumer protection act. Unfortunately, in India, we do not have either of the two. And the only thing that comes to our help wherever the word cyber comes into place is the IT Act. I'm not denying the fact that in IPC, that's Indian Penal Code of 1860, do not get attracted, but majorly it is with the perspective of the IT Act that along with it comes with the provision. So in the case a judicial challenge is there in the Indian courts concerning the infringement of the trademarks by the usage of in domain names, it is IT Act and the Trademarks Act that is brought into. Now, under the IT Act, when you dive as a student to read that particular thing, and is the mentioning of the word like cyber squatting has been done by the legislature, we feel or there is a provision where we felt that no direct involvement of these terms are there. But when we see that how those particular things have been taken, thanks to the judiciary for the wonderful interpretation, thanks to the judiciary for indirectly bringing to something which have been a very common issue under the direct perspective of the trademark violations and the trademark. Now, as I was mentioning, the very important Bisleri case, in an Indian cyber squatting case, also popularly known as the Bisleri case, the Aqua Minerals Limited versus Pramod Bose. What I've also done, that I've made a compilation of these particular judgments that I'll be using today. And if anyone will be requiring this, domain names and the disputes and the case laws in relation to this particular thing, I'll be more than happy in sharing that particular thing. Also to this wonderful team here for the DPIIT at the Osmania University, if they wish, I can even give them this team as well, this compilation of cases that would help them, because they are doing a wonderful job in spreading the awareness in relation to the IP. And this would be my humble submission, and as also a thing that I can be the part of this team in spreading this wonderful knowledge over the IPR issues, and not only the IPR issues, but also the awakening about the intellectual property rights, which I feel as an IP scholar, as an IP student, that is a necessity of this society today. That can bring country like India to the world map. It is already there, but with a stronger IP base, we can even stand as a better country to who's protecting and who's valuing the intellectual property of its own citizens. Another case, which was, I guess he's one of the most respected persons, advocates, politician, and it's unfortunately that we lost him at a very young age, but a wonderful lawyer as well. And it was in relation, and he himself was the party there when his website, the arunjetli.com, was being affected by a cyber squatter, and that thing was brought into the consideration. of how those particular things would be taken into perspective. So this particular case is also, which was decided by the Delhi High Court. Now, the second set of the things that we'll be discussing today is the profit grabbing. Now, in this kind of domain disputes, the defendant indulges in the registration of a domain name similar to that or similar to the others, same or confusing similar trademark or trade name in order to gain profits out of such business. Now, the point which was in blue color, and now for your sake I've highlighted it with red, this is the most important point, that the real perspective of why this confusion or why this similarity, deceptive similarity, I would use a better word for that thing, which is again an IPR term. You can read a lot on the deceptive similarity under the IPRs. This deceptive similarity is only and only brought for gaining the profit. So what does the cyber squatter, or what does the person who is infringing the rights of the trademark holder brings, is that how the particular concepts being taken into consideration. So how a well-known trademark which has making profits, and how those particular things would be taken into consideration. The important case of Satyam Infoware Limited versus CiFi-Net Solutions, you can see the difference, that how CiFi-Net and CiFi with an addition of that alphabet F brings to that particular point. Third set of the problems that we deal is the misspelling and the identical domain name. So the third set of the problems that we see with the domain names is the misspelling and the identical domain names. Before I move, this is also one of the biggest trademark problems or the trademark disputes that we see in the real world as well. Now, with the increase in the business opportunities on the internet, many people tend to register the domain names which appear to be similar to that of already registered domain names. Now, if on a very plain and very layman language, and I guess this is the same thing which the court has also adopted, whenever such a type of a dispute is appearing, the court asks generally and that's where the evidence comes into play. That in an evidence, we generally rule, and here I'm referring to section 101, the burden of proof. So that particular chapter in evidence tells us that the burden of proof always lies on the prosecution. The burden of proof always lies on the plaintiff. In the similar way, the burden of proof is always lies on the trademark owner. I'll repeat, the burden of proof in the cases where a trademark infringement has happened, whether it is a real world or it is a virtual world, it would always lie on the trademark holder. Once the trademark holder, and the only burden on him is that his trademark has been infringed. So once he has proved that, the onus would shift to the defendant, that why he has used the same or a misspelling or an identical domain name, or in the real world, why he has used a misspelled word or an identical name of that what is appearing. The only purpose is to lead to the confusion and misrepresentation in the minds of the general public with regard to the owner of such domain name. I gave you a number of examples like Bisleri being misspelled, parachute being misspelled, Adidas being misspelled, and in the domain name this area, we have this wonderful case, and I'm really thankful to Reddy sir for highlighting this case as well. Now, this is generally considered to be the first case, and you need to see it's the year 1999, where Yahoo Inc. versus Akash Arora, and that was where this is also called as the first domain case which the Supreme Court, which we saw, and it was in relation to, again, something that was reflected in the opening remark made by Reddy sir, yahoo.com and yahooindia.com. To capitalize, and during the 1990 till to early part of 2000, 2005 particularly, we saw that Yahoo was the most used search engine available. Many of us who was growing at that time through our 10th and 11th and other things, we had our first email IDs in the form of or we registered it on Yahoo or Rediff. There were only two that time existing. I'll not say there was not an existence of Google by that time, but how did the Google got capitalized over the market, and now today we see Rediff mail is, and Yahoo is also on that verge of moving away from that particular point. Now, second question was again the Rediff communication versus Cyberbooth, Rediff and the Radiff.com. Info Edge India Private Limited versus Shailesh Gupta, 2002. Naukri.com and Naukri.com. You can see there is for those who are unable to identify, the missing of an A after K. In between K and R, in between K and R. So these are the problems where a misspelling is done. This would be considering a case of a misspelling. This would be the case where identical has been brought. And many a times when you are in a habit of typing it very fast on your keyboards, you might skip an A out there. But for your utter surprise, both of them were existing and both were offering the similar set of services, which brought the original one to question, and the original one being the NAUKRI to the NAUKARI into a major and a minor. The purpose was only and only to deceive the customers to not only move away from this particular website, but also to cause economic benefits to the fake ones. The last set of claims or the last set of dispute formats that we see is the concurrent claims. Now, the concurrent claims arises when two legitimate parties are involved in a dispute over a domain name, where each party claims that they are the true and the legitimate owners of the acquired domain name without any intention of passing off. Now, all my dear friends who have been, I was seeing the list as well, passing off has already been discussed at length in a previous session. Here, what is there? It is only on a point that one website is being claimed by two owners. And that's the reason why it is called as concurrent claims, where two parties are concurrently claiming the website. The website, and a very, very, very important case again, is the Nissan Motor Corp Limited versus Nissan Computer Corporation. Now you see the domains are completely different. One is dealing in the motors, the other is dealing in the computer. A similar case of Indian perspective I can cite here is the Reliance Industries Limited versus Reliance Tires Limited. Now we all know the Reliance is one company who is not into the manufacturing of tires. But he had the same, now the common website that was there, the deceptive one which was in question, the one making for the motor vehicle uses Nissan.net, and the other one that was taking also wanted to register Nissan.net, claiming that my domain is for the computer corporation. Now, in such situations, court, it's a very easy thing, and again, the burden and the onus game that is being played by the courts, one needs to legitimize who is the first owner. Now, the true and legit, both may be and in this case, you can see one is a true and legitimate owner for a motors or the parts, motor parts, and the other one is in the legitimate and the true owner for the computers. But then comes the first usage. Then comes that who is using whose name. And this helps us in taking this particular concept or claims of how this particular jurisprudence behind the claims get affected here. Now, the question that was asked to us, and that made me, after that particular gap of the questions to take it ahead, was how and what are the remedies for the domain name disputes. The URDP, that is the Uniform Domain Name Disputes Resolution Policy, is a policy which is adopted by ICANN that provides a mechanism for the trademark owners to obtain the domain names for the cyber squatters. Now, as you can see, it is called as the URDP, and it's a wonderful policy. it is available. And as an IP enthusiast, which the word was used for you all, I would really request, if you haven't any interest in how the domain name disputes and how the trademarks go, please read this document. This is a wonderful policy that has, and I'm not saying this is a foolproof and an outstanding policy without any lacunas in it. No, but what all ICANN has done here is, by this policy, they have they have come across with a uniform practice. They have come across that how the domain name disputes can be uniformly resolved. And that helps not only in the practices for cyber squatters. I would also request any one of my friends out here who are willing to take this as their PhD topic or something. If you have, or if you are able to read the URDP on the similar lines for an cyber squatter, or I would also request the DPIIT team at the Osmania University, if we can write a joint letter or a petition to the Ministry of IT in our country regarding the disputes, that can, on the similar line, can the Indian government also come on a policy which would be effective in case of cyber squatters. That would be something, a very useful contribution that can be taken. The first dispute under ICANN policy, URDP, was decided on January 14th, 2000, and has been published by WIPO, that is the World Intellectual Property Organization, which provided the single panelist. The case is the World Wrestling Federation Entertainment, which is something we all generally see on our TVs, or have been seeing that on our TVs, versus the Michael Bosman. That is how this particular case was reported. And since then, it's a legacy of those which has been taken. Now, I am now on the verge of ending this particular presentation here. I'll be opening this session in next couple of minutes. That is what I was planned to. That by 6:10, we'll be concluding this presentation, and then left over for 20 odd minutes, we'll open it for the discussions, for some good points that can be made by the fellow participants, by the DPIIT team as well. And if any of the doubts are there, we'll be more than happy in taking those things. So in the past 1 hour and 10 minutes, we were discussing and how a dispute over the domain names in the web addresses is now on an increased size, and how the Anti-Cyber Squatting Act of the US, and there be a strong signal to the cyber squatters that they are not willing to take intellectual property violations in the cyberspace lightly. And that is one thing that, and that there's no problem in learning a good practice from a country if India focuses the main and the soul on the, and I guess, and with this, the new policies with the past 5 or 7 odd years that we are seeing towards strengthening the IPR of our country, the government is doing a wonderful job. All we need is to contribute more, so that we can discuss, we can have discussions, we can have deliberations, we can submit from our ends that these are the good things that is practiced across, and then we can take it ahead. There are some wonderful books on domain names, if for any or by reason that I have also referred during this presentation, is a domain names. It's a wonderful book by Sweet Maxwell. It's a global practice and procedure, how the domain names work. It has a revised edition of 2019. Unfortunately, we do not have a 2020 or a 2021 edition till now. The Indian books consist of copyright and trademark laws relating to computers by Pankaj Jain and Sangeeta Rai Pandey. Trademarks in the emerging cyber property rights by V.K. Uni. The law of trademarks and passing off by P. Narayan. I only refer to the passing of provisions here, nothing else. And that was prior to when I know that the passing off has already been studied, so I removed that slide as well. The sites that I've referred is, again, you can see it's the WIPO's website where the decisions and other things were brought, IRS Internic website, the web hosting domain countries and how those particular things were taken. This is all from my end. This is my email ID. I can be reached on this particular email ID. And this is my assurance to you. Anything on IPR, if anyone has a doubt, please write to me. Feel free to write to me if you want to discuss something. And this is my promise that you'll get a reply within 48 hours of on whatever point on IPR I could give through my knowledge so far in IPR. And to end, I would just say I'm still an IPR student. This is a wide area where I'm still diving to learn more and more, and I'm not going to stop till the time I learned it to the maximum. So thank you so much. I'll stop out here.
For patiently answering all the queries, and also for the detailed analysis that you have provided with respect to internet domain names and its relationship with trademark. Sir, as you have rightly pointed out, there is no specific law that is dealing with domain names and trademark, and the Trademark Act itself is providing the remedies. Sir, now I request our IPR chair, Professor G. B. Reddy, sir, to kindly give his comments.
Thank you very much, Dr. Deevanshu. And it was really a wonderful session. Your lecture has been really enlightening on an emerging area. And I think a lot of work needs to be done in India. No doubt, we have certain judicial developments, but at the same time, I think domain names are going to play a vital role in the coming years in the digital era. And the interface with the other intellectual property rights, and certainly the emerging areas, whether it is artificial intelligence or non-fungible tokens, or similar forms, they will hold relevance for these areas. Thank you very much for enlightening our participants, and we hope to see you in our platform, on our platform once again very soon. And I'm very happy that young academicians are doing exceedingly well, and that is evident today. Thank you so much. Now I request my colleague, not doctor, but maybe to be doctor, Mr. Srinivas Rao, to propose formal vote of thanks. Over to you, Srinivas. Thank you. Thank you all.
Thanks.
Thank you, sir. On behalf of DPIIT IPR-Chair, OU Hyderabad, India, I would like to take this privilege to host this vote of thanks. Today, you have touched upon a most relevant niche topic in areas of trademarks, as we are living in the age of metaverse, virtual reality, and digital. So you talked about the roles of NIC, NSI, ICANN, and the processes involved, the maker-checker format for registering the domain names. So you have graphically shown the statistics, which kind of subdomains are majorly registered all over the world, along with the other results as well. So we are also going through the phase where everyone is trying to make profit by every possible ways without hesitating and bothering if this phenomenon is ethical or non-ethical. Since the concept of IP itself is to protect pecuniary interest of the registered members, the knowledge which you have given on the cyber squatting and the modus operandi was impactful in understanding the whole phenomenon of the domain name war. You mentioned various concepts, including the doctrine of dilution, Anti-Cyber Squatting Consumer Protection Act, which is in US, and you also mentioned that cyber squatting is not under the purview of Indian IT Act in India. So maybe we need to revise, do some technical research in this field to come out with more relevant data and interpretations. And you have rightly mentioned that in one of the comments, requesting the participants to pick up the domain names and the trademarks as their PhD topics. And a similar comment we have received from Dr. Nandini CP also from the participant groups. So you have also mentioned about the case studies like Rediff.com, Satyam versus Sifinet. Similarly, how intentionally the brand names are misspelled. Something like Bisleri, Parachute, Adidas, and Naukri.com, and there are many more. You also touched upon the remedies under UDNR, which is Uniform Domain Names Dispute Resolution, post which you have also given the reference to a couple of books related to today's topic. I hope that is useful for our viewers. And finally, you generously made a statement related to our institution and our efforts. You also graciously acknowledged that our IP works and initiated from DPIIT IPR-Chair OU Hyderabad, and which was an honor for us today, sir. Thank you for that generous statement. So here, on behalf of DPIIT IPR-Chair OU Hyderabad, India, thank you one and all for attending the session and encouraging our work and being part of this beautiful journey of IP academics. With this note, hope to see you all once again. And now we would like to conclude this session with the kind permission of the chair and our today's resource person. Thank you one and all. Thank you, sir.